Yes, sir. Thank you. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare recess of the committee at any time. Pursuant to notice, I now call up H.R. 699 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 699 to amend Title 18 United States Code to update the privacy protections for electronic communications information that is stored by third-party service providers in order to protect consumer privacy interests while meeting law enforcement needs and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. Today, this committee has an opportunity to lead in reforming and modernizing the Electronic Communications Privacy Act, or ECPA. When ECPA was first enacted nearly 30 years ago, Congress declared that the law's purpose was to achieve a fair balance between the privacy expectations of American citizens and the legitimate needs of law enforcement agencies. Reforming this decades-old, outdated law has been a priority for me as chairman of this committee, and I have been working with members of Congress, advocacy groups, and law enforcement agencies for years on many complicated nuances involved in updating this law. While technology has undoubtedly outpaced the law in the last 3 decades, the purpose of the law remains steadfast. I am confident that we can again strike that balance and do so in a way that continues to promote the development and use of new technologies and services and create a statutory framework that will modernize the law to reflect how people communicate with one another today and into the future. ECPA reform has broad sweeping implications. ECPA, and more specifically the Stored Communications Act, governs federal, state, and local government access to stored email, account records, and subscriber information from telephone, email, and other service providers. H.R. 699, at its core, establishes for the first time in federal statute a uniform warrant requirement for stored communication content in criminal investigations, regardless of the type of service provider, the age of an email, or whether the email has been opened. The core of H.R. 699 is a significant reform and should not be dismissed as trifle. It establishes a standard that embodies the principles of the Fourth Amendment and reaffirms our commitment to protecting the privacy interests of the American people. But H.R. 699 goes beyond the creation of a uniform warrant standard in criminal investigations. It dramatically expands the reach of the warrant requirements and imposes new requirements on law enforcement that could impede criminal investigations and threaten public safety. And despite the number of House co-sponsors, the bill as introduced is opposed by virtually every law enforcement and prosecutorial association in the country. The Stored Communications Act is as complex as it is outdated. The committee has worked for months with members of Congress, advocacy groups, and law enforcement agencies on the many complicated nuances involved in updating the law. I am a strong advocate for enhancing Americans' privacy. However, reforms are needed to the Email Privacy Act to protect crime victims and minimize unintended consequences of some of the provisions in the bill. In a few moments, I will offer a substitute amendment that makes several reforms to the Email Privacy Act while preserving the core goal of the bill. This carefully negotiated amendment is the product of years of work on this important issue, and I urge my colleagues to join me in support of the amendment. At this time, I'd like to thank Representative Yoder for introducing the underlying legislation and for working with the committee on this substitute amendment. I'd also like to specifically thank Chris Calabrese and Greg Nojim of CDT for their leadership and hard work on behalf of the coalition of outside supporters of the bill to help craft this amendment. I'd also like to thank the law enforcement organizations for their cooperation on this bill. And last but certainly not least, I want to thank Caroline Lynch, Ryan Breitenbach, and Jason Herring of my staff for their tireless efforts on behalf of the committee over the past months, and in some cases over the past years, to negotiate and deliver this substitute amendment today. I'd also like to thank the gentleman from Michigan, Mr. Conyers, and his staff for their diligent work on this matter as well. Finally, I'd like to say a word about geolocation. We must continue to work to ensure that we protect Americans' privacy, including ensuring sufficient protections for information that reveals the location of individuals. The committee continues to be committed to working on the geolocation issue, and we plan to hold a hearing on the issue. If the short legislative calendar does not allow for a hearing this year, we will hold such a hearing at the beginning of the new Congress. And now it's my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. I want to take a moment first to thank Stephanie Baez for her service here on the committee. She has worked faithfully as the communications director for the House Judiciary Committee, and today is her last committee markup. Raise your right hands. Okay, good. Thank you. Stephanie joined our staff nearly 2 years ago, and she immediately impressed us with her excellent work ethic, dedication, energy, and kindness. As the committee spokesperson for our side of the committee, she developed strong relationships with the press and also spearheaded a long-term effort to update the website. After 6 years on Capitol Hill, Stephanie is unfortunately returning to New York to serve as the Vice President of Communications for the New York Economic Development Corporation. We appreciate your service, Stephanie, to the Judiciary Committee and to the House of Representatives, and we wish you well.
Would the gentleman yield?
Of course.
I thank the gentleman for yielding, and I'd also like to take the opportunity to thank Stephanie for her hard work. I know from the communications team on our side of the aisle that they have worked closely and cooperatively with you on many occasions, and we appreciate your willingness to work with us and everyone else here on the committee. And we also, on our side, join in wishing you the best in your endeavors, even if they may be in New York.
Thank you. Mr. Chairman and members of the committee, in 2014, in a unanimous ruling delivered by Chief Justice Roberts, the Supreme Court concluded that the police may not search a cell phone without first demonstrating probable cause. Citing an obvious Fourth Amendment interest in the vast amount of data we stored on and accessed from our personal devices, the court wrote, and I quote, "The fact that technology now allows an individual to carry such information in his hand does not make the information any less worthy of the protection for which the founders fought." Our answer to the questions of what police must do before searching a cell phone seized incident to an arrest is accordingly simple: get a warrant. With that decision, the court took a bold step towards reconciling our Fourth Amendment values with the advent of modern communications technology. Now today, this committee takes a similar step to reconcile our interests in privacy and due process with the realities of modern computing. H.R. 699, the Email Privacy Act, recognizes that the content of our communications, although often stored in digital form these days, is still worthy of Fourth Amendment protections. So to the investigators and government agents who seek access to our email, our advice is accordingly simple: get a warrant. It's an idea whose time has come, and this bill will allow us to move to a clear, uniform standard for law enforcement agencies hoping to access the content of our communications, namely a warrant based on probable cause. In addition, 699 would codify the right of the providers to give notice of this intrusion to their customers, subject to certain exigent circumstances, that also must be validated by the court. And the measure would accomplish these goals without any significant interruption to the way our law enforcement agencies investigate criminal activity. It's no wonder, then, that the Email Privacy Act enjoys more support than any bill that has not yet seen action on the floor of the House of Representatives. At last count, it enjoys 314 co-sponsors, including 196 of my Republican colleagues, 118 Democrats, and a majority of this committee. The legislation, to me, is long overdue, and I'm glad that we could work out our remaining differences and bring it to consideration today. And so I urge my colleagues and thank them for their support of 699 as amended by the proposal before us today. And I also thank the chairman and yield back the balance of my time.
Thank you, Mr. Conyers, and without objection, all other members' opening statements will be made a part of the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 699, offered by Mr. Goodlatte of Virginia, Mr. Conyers of Michigan, Mr. Issa of California, Mr. Nadler of New York, Mr. Forbes of Virginia, Ms. Jackson Lee of Texas, Ms. Delbene of Washington, and Mr. Bishop of Michigan. Strike all after the enacting clause and insert the following.
Without objection, the amendment in the nature of a substitute is considered as read, and I'll recognize myself to explain the amendment. This substitute is a carefully negotiated agreement to update the procedures governing government access to stored communications, content, and records. This amendment retains the core goal of H.R. 699 to establish a uniform warrant requirement for stored communications content in criminal investigations while also protecting and preserving privacy and public safety interests. The amendment removes from the bill a requirement that law enforcement serve the warrant on the target of the investigation. For 3 decades, ECPA warrants have been executed with the provider because, as with any other third-party custodian, the information sought is stored with them. This proposal raised profound public safety and operational concerns with a myriad of potential negative consequences. Instead, the substitute amendment authorizes the provider to notify its customers of receipt of a warrant, court order, or subpoena unless the provider is court-ordered to delay such notification. The substitute reinstates a provision from current law that delineates which remote computing service providers, or cloud providers, are subject to the warrant requirement for content in a criminal investigation. ECPA has traditionally imposed heightened legal process and procedures to obtain information for which the customer has a reasonable expectation of privacy, namely emails, texts, photos, videos, and documents stored in the cloud. The substitute amendment preserves this treatment by maintaining in the statute limiting language regarding remote computing services. The substitute amendment authorizes the court to require a date for return of service of the warrant. In the absence of such a requirement, email and cloud providers must promptly respond to warrants for communications content. ECPA currently makes no distinction between content disclosed to the public, like an advertisement on a website, versus content disclosed only to one or a handful of persons, like an email or text message. The result is that law enforcement is required to obtain a warrant even for publicly disclosed content. The substitute clarifies that commercial public content can be obtained with process other than a warrant. Lastly, the substitute amendment clarifies that nothing in the law limits Congress's subpoena authority to obtain information from third parties in furtherance of a congressional investigation or oversight, and makes a number of technical and conforming improvements to the law. This substitute amendment represents months of work to ensure that reforms to such a broad sweeping law reflect Congress's responsibility to make sure our laws keep pace with advancing technology. And it does so in a way that enhances privacy protections without sacrificing public safety. I urge all members to support this amendment, and without objection, a letter from the Coalition of Civil Society Groups, Trade Associations, and Private Industry, and letters from federal, state, and local law enforcement and prosecutorial organizations will be made a part of the record. It's now my pleasure to
Chairman.
recognize the gentleman from Michigan, Mr. Conyers, for his remarks on this amendment.
Thank you, Chairman. Good luck. Thanks to you and your staff for working with me and my staff for working together to develop the amendment before us now. I also want to recognize and appreciate the members of the Digital Due Process Coalition, many of whom are represented here today, for their tireless dedication to the work of modernizing federal statutes for the Internet age. Over the last few weeks, my colleagues, as we've worked out our few remaining differences on this bill, we've crafted what I believe to be an effective compromise. This amendment addresses many of the concerns expressed to us by local, state, and federal law enforcement agencies, and it does so while preserving the privacy and due process interests at the core of the original bill. Wherever possible, we've retained the important changes proposed by the underlying bill, and central to these changes is the elimination of the so-called 180-day rule, and any distinction between opened and unopened email in the statute. We've always agreed that a simple warrant for content standard is a better approach to protecting our privacy. I should also note that the absence of a special carve-out for the civil agencies, this committee quickly reached consensus that those proposals were unworkable, unconstitutional, and sometimes both. I would have preferred to keep the notice provisions of the original bill, which are absent from this substitute. In the digital world, no amount of due diligence necessarily tells us that the government has accessed our electronic communications. The government should have an obligation to provide us with some form of notice when intruding on a record of our most private conversations. But I understand that not everyone shares this view, and I'm willing to compromise. For now, in order to advance the important reforms that we will adopt today, I'm proud of the work that we've done. This legislation is 6 years in the making, and it should not be delayed any further. And accordingly, I thank my colleagues for their support for the manager's amendment, and I yield back the balance of my time, Mr. Chairman. Thank you.
The chair thanks the gentleman. For what purpose does the gentleman from Utah seek recognition?
I move to strike the last word.
The gentleman is recognized for 5 minutes.
I thank the chairman, and I want to thank him profusely for his good work and commitment on this bill. I stand in support of the manager's amendment and the underlying bill. This is an issue that desperately needs to be addressed, and I think we've done so in a good bipartisan way. I want to thank our colleague, Mr. Yoder, who's worked tirelessly to put together a broad coalition of people on both sides of the aisle, both on this committee and outside this committee. But, Mr. Chairman, you have truly brought together people from with disparate thoughts and perspectives, and come up with something I think is very palatable, very fair. Will give a great update to the law as it's needed. And I also want to thank you for your commitment on the geolocation issue, which does need to be addressed, to have a candid hearing about what is happening and what is not happening. I look forward to that hearing. I thank you for always being having an open ear and knowing that we have to address that issue as well, and look forward to doing that in the future. So with that, I will yield back the balance of my time.
The chair thanks the gentleman. For what purpose does the gentlewoman from California seek recognition?
Mr. Chairman, I move to strike the last word.
The gentlewoman is recognized for 5 minutes.
I think that codifying the Warshak requirement for email and clarifying that Congress believes, just like the rest of the public, that there's an expectation of privacy for things stored in the cloud is an important change. And I'm glad the committee is moving on this bill, and I applaud the chairman for doing so. as well as the ranking member for his diligent work. I also wanted to recognize, however, the chairman's statement on the importance of reforming the disclosure and interception of geolocation information, because that's an important issue to both of us, and I am welcoming the prospect of hearings on this measure. Now, the courts are moving in the right direction on geolocation, but there is still a void when it comes to historical geolocation information, and that's really a very large problem, because protecting information about where you are goes beyond the Fourth Amendment. It impacts the First Amendment. If you're afraid you're being watched, it impacts your right to free speech, your right to assembly, even potentially your right to practice your religion. People act and think differently when they know or suspect that they're being watched. And so we know from the data from AT&T and Verizon that this is a huge issue. I'll just give you some stats that I recently received. AT&T received a total of 9,776 warrant requests for wiretaps and stored communications. I don't have the subpoena information. Verizon received a little over 5,500 in the last 6 months. However, in those same time periods, AT&T received over 76,000 requests for geolocation information, and Verizon over 24,000. So this is a very large issue. Many states have taken the lead on this. California just passed a law protecting geolocation information with a warrant requirement, and I believe, Mr. Chairman, your own state of Virginia also requires a warrant for geolocation information. So I look forward to working with you in the hearing in the near future, and I support this bill, and I yield back the balance of my time.
The chair thanks the gentleman. For purpose, the gentleman from New York, seek recognition.
Mr. Chairman, to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. It has long been evident that we need an update to the laws impacting electronic communications and privacy, and I'm pleased today that the House Judiciary Committee will take a major step forward to do just that with the long overdue passage of the Email Privacy Act. Back in 2009 and 2010, when I was the chair of the subcommittee on the Constitution, we held multiple hearings on ECPA and began to seriously consider reform to the country's electronic communication and privacy laws. During the 112th Congress, Ranking Member Conyers and I introduced the Electronic Communications Privacy Act Modernization Act of 2012, which would have required law enforcement to obtain a warrant based on probable cause before searching email. That approach, now embodied in the Odor Polis Email Privacy Act and in the Chairman's mark, is what we are here to consider in the Judiciary Committee today. The Email Privacy Act requires the government to obtain a warrant in order to access an individual's electronic communications from a third-party provider, protecting Americans' privacy rights while still enabling law enforcement to do its job. Current law is inconsistent and unclear regarding the standards for government access to the content of communications, and a single email is potentially subject to multiple different legal standards. Clarifying the laws will help industry stakeholders who currently struggle to apply the existing outdated categories of information to their products and services, and it will provide a clear standard for law enforcement, but one that ensures that ECPA conforms with the Fourth Amendment protections we are guaranteed under the Constitution. In an era where government access to people's private information held by third-party providers has become far too easy, Congress is finally taking steps to update our laws to reflect our new understanding of what it means for people to be, quote, secure in their persons, houses, papers, and effects against unreasonable searches and seizures, close quote. I applaud this landmark legislation and am proud to co-sponsor the Chairman's mark in what is a critical step forward to ensure that our laws strike the right balance between the interests and needs of law enforcement and the privacy of the American people. And I also want to say I appreciate the Chairman's commitment to holding hearings on geolocation, because that is obviously the next step in this ongoing campaign to update our laws regarding electronic communications.
Chair thanks, gentlemen.
Thank you. I yield back.
Chairman.
For purposes of the gentleman from Pennsylvania, Mr. Marino, seek recognition.
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Chairman. Mr. Chairman, I want to thank you and your staff for all the work you put into the bill we are considering today. I know that you and your staff have worked tirelessly to draft language that balances the many interests and issues created by a legal revamp that is 30 years in the making. I greatly appreciate this effort and your constant cooperation with me and my staff. In 1986, the original drafters of ECPA could not have envisioned the interconnected lives we live in today's digital world. New technologies present new opportunities and experience for users. Electronic communications are a daily necessity for American citizens and businesses to send, receive, and store their most important information. Many of these innovations have been developed and driven by U.S.-based companies, providing good-paying jobs here, and the use of American-made electronic communications and remote computing services across the globe. At the same time, however, new technology presents new challenges for law enforcement in their obligation to protect us and keep us safe. As a former district attorney and a United States attorney, I personally understand the complexities of a modern-day investigations and criminal prosecutions. Yet, from the founding of our nation, we have cherished our privacy. The Fourth Amendment's papers and effects are today's emails, tweets, and posts. We must keep this charge in mind. The intent behind ECPA to protect privacy while balancing the legitimate needs of the law enforcement access to information must be preserved. Today's bill marks thoughtful steps in the direction by ensuring the requirement that law enforcement must obtain a warrant for the electronic content it seeks. But for over a year now, I've worked with my colleague, Representative Susan DelBene, on an issue related to one we consider today. How do we address the issue of law enforcement access to data that happens to be stored abroad? Ms. DelBene and I are proud of the progress we have made bringing attention to this question and the need to answer it in a thoughtful, balanced way. Over 130 bipartisan members have co-sponsored our bill, the Law Enforcement Access to Data Stored Abroad Act, or known as LEADS. Mr. Chairman, I am grateful for your support on this issue and the opportunity this committee had to explore it during a hearing earlier this year on the conflict of law question faced by cross-border data flows and law enforcement requests for that data. We look forward to working with you, our colleagues on the Judiciary Committee, and stakeholders from both industry and law enforcement to ensure we address the critical issue related to ECPA reform. I also want to thank Ranking Member Conyers for his support as a co-sponsor of our bill as well. The dual interest of user privacy and access to this information are just as important when data is stored in foreign countries as when it is stored in the United States. Adding to the complexity of the issue are our existing legal assistance agreements with foreign countries. Unfortunately, the current MLAT process is inefficient and cumbersome. I am encouraged by efforts already underway at the Department of Justice to improve this. Under the leadership of this committee, we in Congress should continue to explore ways to reform the MLAT process while keeping an open mind to alternatives, including prospects for new bilateral agreement being negotiated with the United Kingdom. We have an opportunity to set the standard for policies that allow for balanced and efficient access to information for law enforcement while simultaneously protecting privacy, civil liberties, and human rights. Mr. Chairman, as we move ahead, I'm sure I can look for you for assistance as we continue to explore ways to achieve these goals. And thank you. I look forward to...
Would the gentleman yield?
Yes.
I want to thank the gentleman for his work on the LEADS Act and related issues, and look forward to working with him as we move forward.
Excellent. Thank you so much. And with that, thank you, and I yield back.
Chair thanks the gentleman. For purposes, the gentlewoman from Texas seek recognition.
Mr. Chairman, to strike the last word.
Gentlewoman is recognized for 5 minutes.
Mr. Chairman, thank you, and let me thank the cooperative spirit and the hard work of the ranking member working with you, Mr. Chairman, on resolving some of the issues that have been expressed by the stakeholders. I support this bill, the underlying bill, to update the Electronic Communications Privacy Act, a law that both protects the privacy of our email communication and provides a critical tool for law enforcement to investigate crime. I'm pleased to have been an original co-sponsor of this bill, which has 314 co-sponsors enjoying overwhelming bipartisan support, and I'm pleased the committee has worked on it to improve it so that it can be brought up today. The Electronic Communications Privacy Act, or ECPA, was enacted in 1986. The statute is outdated and provides unjustifiably inconsistent standards for law enforcement access to stored communications. The law was designed at a time when few of us used email or could have imagined a world in which we would securely share information, edit electronic documents online with others, or where businesses could input, store, process, and access all data related to their operation. However, it is important to have as a premier point is that of privacy, and we are very much in line with the organizations that provided us with a letter expressing their concerns. The law was designed, as I said, when we were not using email as much. The outdated, inconsistent, unclear aspects of this statute undermine both our privacy interests and law enforcement interests. It is critical that we enact the central reforms provided by this bill. For instance, a probable cause standard should apply to the government's ability to compel a communications provider to disclose a customer's email message, no matter how old the message is. Currently, the statute requires the government to obtain a warrant based on probable cause to compel disclosure of an email that is in storage for 180 days or less. However, the statute only requires a subpoena for the government to obtain email messages that are older than 180 days. This makes no sense because citizens have the same reasonable expectation that these stored communications are private. Therefore, we must change the law so that the higher standard applies regardless of the age of these communications, and H.R. 69 would accomplish this. In addition, the law does not adequately protect communications stored in the cloud by third parties on behalf of consumers, and a probable cause warrant should be required for government access. ECPA additionally provides a lesser standard for some cloud storage than it does for many communications stored by electronic communication services. To further complicate matters, many companies provide both communication services and remote storage, making the services to the same customer difficult to separate for purposes of determining which standard applies. Applying inadequate and unclear standards to government access to cloud communications undermines consumer confidence in cloud privacy, threatens to hamper the development of this important engine of economic growth. And H.R. 699 addresses this issue by providing clear, consistent probable cause standard for access to contents of stored communications for which customers have reasonable expectation. The substitute, which I am supporting, again answers concerns, and I'm glad that it provides responses to some of the questions that have been raised. In particular, it adds language authorizing the court to include a date by which providers must disclose information sought in the warrant. Among other things, it removes language requiring the government to serve a copy of the warrant or the subscriber or customer, and allows the provider to provide a notice, which I think is very important. It removes the language which would have limited the scope of non-content records available with a warrant or court order to only those records available via subpoena, and removes the outdated provision that authorized disclosure of non-content records in cases of telemarketing, as well as the rule of construction clause preserving the ability of the government to obtain public commercial content with process other than a warrant, removes requirement of government to seek delayed notice against itself, clarifies that nothing in the Email Privacy Act precludes acquisition of wire or electronic communications. I think the main point is, after noting the letter that was sent by any number of individuals and stakeholders, including Amazon, American Civil Liberties, American Library Association, which the ranking member has included in the record, I think we've come to at least a understanding of the balance of importance of investigations, but also the right to privacy. I support the underlying bill, and am glad to co-sponsor the manager's amendment and ask for support of the bill and the manager's amendment. With that, I yield back.
Chair thanks the gentlewoman. For the purpose of the gentleman from Texas, Mr. Farenthold, seek recognition.
I'd like to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman, and I'd like to applaud the efforts of Mr. Yoder and Mr. Polis with the underlying bill. It had 314 co-sponsors as written. I understand that the manager's amendment paves the way for stopping some of the folks who were opposed to it from raising too much of a stink. I guess we've got the situation here that compromise and getting something done is ending up with something not everybody loves, but is something everybody can live with. I do think that EPCA definitely needs reform, and this goes a long way to doing it, though I join some of the concerns my colleagues have expressed with the lack of notice requirements, the failure to include geolocation protection, and the lack of a suppression remedy in this. But again, nothing's perfect. We've got commitments to move forward on a lot of these, so I'm really happy that we're going to get this done, and thank you for your hard work on it, and look forward to voting for it here and on the floor. You yield back.
Thanks, gentlemen. For what purpose does the gentlewoman from Washington seek recognition?
Move to strike the last word.
Gentlewoman is recognized for 5 minutes.
Thank you. I want to thank you, Mr. Chair, for holding this markup. This has been a top priority of mine since I was elected to Congress, to make sure we reform the Electronic Communications Privacy Act. It addresses such a core issue in terms of protecting the privacy of people's personal information and upholding that in our digital world. And this is a great first step. And as many of my colleagues have said, it's a good first step. I want to thank Congressman Yoder and Congressman Polis for introducing the Email Privacy Act. But I also agree with my colleagues, we need to address other issues going forward, including geolocation, as Mr. Chafis and Ms. Lofgren have posted out. And I want to thank you, Mr. Chairman, for your commitment on moving forward on geolocation. I also agree with my colleague, Mr. Marino, that we've got to continue the discussion this committee has begun about the conflicts of law and accessing data stored overseas by American companies. I want to thank Mr. Marino and our Republican colleagues who've been supportive and part of this effort, as well as my colleagues on this side, Ranking Member Conyers, Mr. Jeffries, Mr. Johnson, Mr. Peters, Mr. Pierluisi, Ms. Bass, Mr. Cohen, and Mr. Gutierrez for all of their support in this conversation. That's another area we need to move on. So again, this is a great first step, and I look forward to working with you as we move forward, and yield back the remainder of my time.
Chair, thanks, gentlewoman. For purposes, the gentleman from Texas, Mr. Poe, seek recognition.
Mr. Chairman, I move to strike the last word.
Gentleman is recognized for 5 minutes.
I want to thank the chair for bringing this legislation up. In the big scheme of things, we have a lot of committees in Washington, D.C., in the House of Representatives. We've got the committee that deals with taxes and energy and agriculture, transportation. A lot of committees doing a lot of good things, but this is the only committee in the House of Representatives that deals with the Constitution and protecting the constitutional rights of Americans. That's why I think that this committee is very important, because we're the last one standing, in my opinion, on protecting the rights in the Constitution. And we're talking about today the Fourth Amendment. You look at countries all throughout the world, even democracies, they don't have the Fourth Amendment. The United States is unique in its establishment of the Fourth Amendment, protection of privacy of citizens and individuals in this country. And we ought to continue to make sure we fight for that, because we are the last ones who are going to fight for the Fourth Amendment. This legislation protects the right of privacy. That's good. As mentioned before, I hope we move forward with some other issues. The right of privacy dealing with drones flying over our head, both civilian and government drones. We have to handle that. That's our responsibility. It's not the FAA's responsibility. There was a book written in 1948, some of us studied in high school, called 1984, written by Orwell. And I remember, actually, as I mentioned last week, I have no life, so I read the book again over the weekend. And I had remembered how when we discussed this in English literature, how absurd students like myself thought this would ever be, that 1984 would actually come to pass. Well, it's worth the read again. It talks about the thought police. It talks about surveillance by government on the citizens, where there's a camera on every corner, like maybe they have in England today. It talks about hidden microphones and telescreens, surveillance of government on the people. That's what this committee has to fight against, surveillance of government on the people. And I think that this is a good step forward in doing that. It is our responsibility. Bipartisanship is, I think, good. That's good for members of the House to have so many people support this idea of the Fourth Amendment protections. I do think we need to go a little further. Ms. Lofgren has introduced legislation on geolocation. I think that's something that I'm glad the chairman has said we're going to deal with that, but the idea that government can follow the citizens around wherever they go in the whole U.S., I got a problem with that. That's kind of 1984. And I'm not the first one who said that. In the U.S. versus Jones back in 2011, a case about government putting a tracking device on a car. The Supreme Court Justice Breyer made the comment to the government about this geolocation device. He said, if you win this case, then there is nothing to prevent police or government from monitoring 24 hours a day the public movement of every citizen of the U.S. So if you win, suddenly we produce 1984 all over again. So I think this legislation is important. We need to move forward to protect the Fourth Amendment. We have it. Other countries don't. We have an obligation as a committee and members of the House of Representatives to protect the Fourth Amendment against government intrusion. And I'll yield back to the chairman.
Chair thanks, gentlemen. For purpose, the gentleman from New York, seek recognition.
I move to strike the last word.
Gentleman is recognized for 5 minutes.
Well, thank you, Mr. Chairman, for your leadership, and I want to thank the ranking member, all of my colleagues in government, committee staff, for their hard work in moving this important piece of legislation forward. Advances in technology often outpace existing law, and the Electronic Communications Privacy Act has been no exception. We know that the Fourth Amendment protects individuals from unreasonable government searches, and courts have guaranteed this protection by requiring the government to obtain a warrant supported by probable cause in criminal proceedings. Yet the existing law allowed the government to legally circumvent the Fourth Amendment and its warrant requirement if it sought the content of electronic communications through a third party. The Electronic Communications Privacy Act contained distinctions between types of computing services and stored electronic communications that failed to fully recognize and uphold Fourth Amendment protections in the modern digital era. While the privacy protections contained in current law may have been adequate in the 1980s, they no longer reflect the reality of today's technology. As technology advanced, the law did not protect the privacy rights of everyday Americans. The distinctions between opened and unopened emails, communications stored for more than 180 days, or the type of computing service at issue permitted the government to obtain almost the entire record of email communications and its content from any American citizen through a third party without obtaining a warrant supported by probable cause. That was wholly inconsistent with the Fourth Amendment and the intentions of our founding fathers. For several years, members on both sides of the aisle, the technology industry and privacy advocates, have noted the need to reform the Electronic Communications Privacy Act so that the Fourth Amendment rights of all Americans could be fully protected. I'm thankful today that we are doing exactly that. H.R. 699, of course, eliminates the archaic and outdated 180-day rule, any distinction between opened and unopened emails, and establishes a more robust single legal standard through which the government can obtain the contents of electronic communication from a third party. The bill's warrant requirement ensures that the privacy rights of American citizens are duly protected in the modern technology and innovation era, and upholds the Fourth Amendment in a manner consistent with its original intent. Moving forward, as other members have indicated, I look forward to working together with all of my colleagues in the committee to address other outstanding issues such as geolocation, access to overseas data with the leadership of Mr. Marino and Ms. Del Bene, encryption, and other privacy concerns related to the modern technology era. I look forward to addressing these issues as comprehensively as we have addressed this one, and I yield back.
Chair thanks the gentleman. Are there any amendments to the amendment in the nature of a substitute? The question is on the amendment in the nature of a substitute to H.R. 699. All those in favor respond by saying aye. Aye. Those opposed, no. Opinion of the chair, the ayes have it, and the amendment is agreed to. Reporting quorum being present, the question is on the motion to report the bill H.R. 699 as amended favorably to the House. Those in favor will say aye.
Aye.
Those opposed, no. The ayes have it, and the bill as amended.
Mr. Chairman, may I have a recorded vote?
A recorded vote has been requested, and the clerk will call the roll.
Mr. Chairman,
Aye.
Mr. Chairman votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Smith votes aye. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Issa? Mr. Issa votes yes. Mr. Forbes? Mr. Forbes votes aye. Mr. King? Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Jordan? Mr. Jordan votes yes. Mr. Poe? Mr. Poe votes yes. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Labrador? Mr. Farenthold? Mr. Farenthold votes aye. Mr. Collins? Mr. Collins votes aye. Mr. DeSantis? Ms. Walters? Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Mr. Trott? Mr. Trott votes aye. Mr. Bishop? Mr. Bishop votes yes. Mr. Conyers? Mr. Conyers votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes yes. Ms. Jackson Lee?
Aye.
Ms. Jackson Lee votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Pierluisi? Ms. Chu? Mr. Deutsch? Mr. Gutierrez? Ms. Bass? Mr. Richmond? Ms. Delbene? Ms. Delbene votes aye. Mr. Jeffries? Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Peters? Mr. Peters votes aye.
The gentlewoman from California, Ms. Chu.
Ms. Chu votes aye.
Oh, the gentlewoman from California, Ms. Walters.
Ms. Walters votes aye.
The gentleman from Tennessee.
Mr. Cohen votes aye.
Has every member voted who wishes to vote? Clerk will report.
Mr. Chairman, 28 members voted aye, 0 members voted no.
The ayes have it, and the bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views, and without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. S-125, the Bulletproof Vest Partnership Grant Program Reauthorization, will be marked up next week. That concludes the business of the committee today. I want to thank all of their members for the very cooperative nature in which we have brought this bill out of the committee. I want to congratulate the gentleman from Kansas, Mr. Yoder, and I thank all of you for your participation. The meeting is adjourned.